Who inherits property if there's no will? If your loved one passes away without a will, California's intestate succession laws are going to dictate how the estate property is going to be distributed. However, these laws only dispose of assets that otherwise would have been subject to probate or covered by that will. Some examples of assets that won't be affected by estate's intestacy laws include 1. Funds in a living trust. 2. Property that's owned jointly, such as real estate or bank accounts. 3. Proceeds from life insurance. 4. Payable-on-death or POD bank and retirement investment accounts. These assets will be inherited by a surviving co-owner or a named beneficiary without regard to the intestate succession laws. What is intestate succession? Intestate succession is the process by which estate assets are distributed when someone dies without a will, or if a will exists but doesn't entirely dispose of the estate's assets. California's intestacy statutes detail the specific order in which family members receive, inherit, and what from an estate. Here are some examples of how California's intestate succession laws would require estate assets to be distributed in some different situations. 1. If the deceased was married with no surviving children, parents, siblings, nieces, or nephews, all the assets would be distributed to their surviving spouse. 2. If the deceased was unmarried but had children, all assets would be split equally between the children. If one or more children died before the deceased, the children of that deceased child would split their share equally. If the deceased was unmarried and had no children, then the deceased's parents would inherit the assets. And if the parents are deceased, then siblings, aunts, uncles, and so forth. These are just a few instances of how California's complicated and sometimes confusing intestate succession laws can play out. If a family member has passed away and did not leave a will, an experienced probate attorney can explain how the estate assets should be distributed in your particular situation. What is an executor of an estate? An executor of an estate is the person who's responsible for managing the probate process when a decedent leaves a will. An executor is usually appointed or otherwise identified in the will itself. The duties of an executor include 1. Marshaling or gathering all of the estate assets. 2. Paying estate debts and taxes. 3. Selling estate property, if appropriate. And 4. Distributing estate assets in accordance with the terms of the will and upon court order. If someone dies without a will, an administrator will be appointed by the probate court to manage the estate. Administrators generally do the same thing as executors, but they're appointed by the court without having been nominated in a will, as an executor would have been. Can an executor of an estate take estate property for themselves? No. While an executor of an estate may be able to sell estate property as needed, they cannot take property from the estate for themselves to keep it, use it, or for their own benefit. An executor may be able to sell estate property without receiving court approval, but often, especially in the case of real estate, they usually need court approval before they can sell. In any case, the money that's made from selling estate assets belongs to the estate, and it's going to be distributed to the beneficiaries under the will. Executors have a fiduciary duty to follow the will when distributing estate property. This means they can't take property or money from the estate for themselves unless it's specifically left to them in the will, and even then, only when they get approval from the court and the court orders it. Do I need a probate lawyer to contest an inheritance? Even though you're not legally required to have counsel, an experienced probate litigation lawyer is going to give you your best shot at success. While you generally cannot contest an inheritance under intestate succession laws, you might be able to make other claims against the estate to receive a share. A probate litigation attorney can advise you on your rights and provide legal guidance on the best way to proceed. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email anytime. The consultation's always free. Thanks for watching.